So hello everyone. I want to welcome everybody to the first of session that we have from DFDL. We're going to discuss COVID resilience, and as we all well know, COVID has been pretty devastating and difficult for everyone to deal with. We're long on a year and a half now, and there have been a lot of changes and a lot of accommodations that have had to be made across the board. So this is going to be the first session in a series of 3 sessions. This first session will focus on workforce restructuring. So what I want to do first is give a little introduction to the firm, and then we'll give a little bit of an introduction to our guest speaker, Tan, who's a partner in our Bangkok office. And then we'll move on through a series of questions discussing how your organization can remain resilient and address workforce resiliency issues during this period. So just a quick introduction of DFDL. DFDL is ASEAN. We've been here for 25 years, originally from Vientiane. We operate all throughout ASEAN, and we're sort of an ASEAN +1 because we do have a practice in Bangladesh. So we provide full service across the board, and some of those services will be highlighted today. We're doing our presentations on workforce, banking and finance, and also real estate through each of the 3 sessions. So next slide, if you want to go through to the next slide, please. Can we move forward to the next slide? Hello? Adriana or Segoli, can you move forward the slide? Okay, I guess there may be an issue with the slide at the moment. Okay, so the next slide is actually just going to present several of the places where we happen to operate and give you a full understanding of sort of the extra desks we have also. So we have 5 extra desks beyond the ASEAN region. So we have a China desk, India desk, a French desk, Japan desk, and Korea desk. So beyond DFDL introduction to the firm, I want to now turn really quickly. Again, we only have 20 minutes, so I want to sort of jump into the material. But first, I want to introduce our guest speaker for today. Our guest speaker is Kraisorn, also locally known as Tan. He's been with the firm for 15 years. He works in the Bangkok office. He's stationed in the Bangkok office and is a partner here. He's been with the firm since the Bangkok office was open in 2006. He, like most of the professionals in our firm, wear several different hats. So he has 3 basic practices, although he does other work, of course. But his 3 main practices are mergers and acquisitions, so M&A work. He's also the head of Thai compliance, and he also specializes in HR and employment law practice. So with that, I sort of want to move over and get the discussion started. So Tan, if you could, I guess, we're focusing obviously on workforce and workforce restructuring, which has been a big issue, probably one of the main issues over the last 18 months or so. So I'm just wondering if you can maybe give us a little bit of a general background on what kind of approach is recommended when you're going through workforce restructuring.
Yes, hello everyone, good afternoon. I think that this is the good time for us to revisit this topic again, because we have gathered and accumulated certain experience during the first wave of the pandemic, where we help a lot of clients in creating and helping to set up measures to really withstand and make the business afloat during the tough times. General approach that we have seen from our clients, many is from hospitality businesses and restaurant businesses that have a direct effect on this pandemic situation. So we have seen in 2 categories. One is the internal change of work conditions, and another is redundancy. So in internal chain of work conditions, what we have seen in the markets would be around leave without pay, part-time arrangement, workforce rotation, salary, or monetary benefit deferments. So, and another one is a temporary shutdown or partially shutdown of the business. So when we refer to shutdown, it could be simply set out to set up workforce. So partial suspension of business means that you can also set out to set up workforce to work week in, week out, for example. So in terms of internal chain of work conditions, there will be options that you require consent from the employee, which is all issues in relation to the chain of their work conditions, either to put them on part-time, work rotation, salary and monetary benefit deferments. These options require explicit consent from the employees. And this will be one of the first thing when our clients consider to impose on their workforce. So the key legal requirement around here is that you need an explicit consent. Implied consent may be applicable, but it will entail a risk of litigations. So for this option, it has been pursued on a consent basis. So the key issue in our experience would be that an effective communications must be done. What we've seen in terms of success case, all the employers have a town hall or have a strong communication and provide information to their employees on the financial distress and tough situation of the company. The more the employer provide, the better understanding the employees will have. Another successful indicators also indicates where the executive of the companies will be one of the first group that need to be subject to this type of measures. And another useful fact is also to provide to the employees in the town hall will be also what other measures other than workforce cost cutting that the company have tried. If you can,
if I can jump in real quick, I think before we sort of get to a discussion of sort of the communications and things like that, maybe if we could step back a little bit and cover, first of all, how you effectively go through the changes or the proposed changes first. So when it comes to actually changing the workforce and the labor force and the terms of their employment, et cetera, what do Thai companies need to look out for specifically that may prove problematic, or what kind of format do they have to go through?
So then, the simple ways of document this, since you require explicit consent after the successful communications, you would need to document it in writing. It could be in the form of a simple one-page letter informing the terms of agreement between the employer and the employees, and this letter must be signed by the employees, each employees. It's also possible where if you have a IT system where you can provide acceptance by clicking or e-signatures. That's what we have seen. So this is a legal format to do this, to document this.
So what if so it sounds like, I mean, obviously there are a lot of choices that the employers can take, and it will obviously need to be put in a formalized reform to the terms and conditions of the employment and things like that, and agreed. What if you have an employee that doesn't agree, or some employees who don't agree to have the terms of their work changed or modified?
Yes, so that there will always be a high possibility that a number of employees will refuse or reject to cooperate. In this case, the best way we've seen is to try to enter into mutual separation agreement with the group of employees. We have a discussion where our client think that would this be the benefit for those who don't cooperate with the organization? Would this sort of a reward if they get the mutual separation package? But what we've seen is that to really encourage the employee who refuse to enter into mutual separation and with certain package would also it's not a reward in itself, because in this economic situation it will be quite difficult to find a new job. So this simply and those who employee who cooperate still can retain their works and have and of course all the employees all the employers we have helped quite recognize this cooperation. So there could be, and they tend to have an incentive package when things got better. So this should be part of the conversation to discuss not only with those employees who refuse, but also the employees who decide to join in.
And actually, having sort of touched on the employer communication process, I don't know that we need to revisit a lot of that, other than obviously to recap what you said, which is that the main difficulty around this space may be the actual communication of the process and everything to the employees, right? And how to best effectuate that. So if we can actually move on to the next question, which would be about employee representatives, and can employee representatives be furloughed? And if they're furloughed, are they allowed to continue on as a representative? So you may actually want to address what an employee representative is in the first place. Some people may not be familiar with that concept.
Yeah, so in the organization where you have more than 50 employees, you have employees have the right to set up an employee committee. And this employee committee have the right to negotiate and start the collective bargaining agreements with a collective bargaining process with employees. And these members of employee committee by law are not prohibited from dismissal unless you receive the court approval. And another legal prohibition is around the employee representative, any person that involved in the process of collective bargaining with the employer. This group of employees can claim against the employer on any unfair practice imposed on them by the employer. So this would cover those measures in relation to reduction of work benefits and so on, right? But in this second issue on unfair practice claim, there must be a proof of fact that this is done discriminately and unfairly and with the intention to disencourage the employees from continue the collective bargaining discussion with employers. So it's so long as you provide fair and objective measures that discuss with all the employees, this measure will be fine too.
And I would assume that part of this is put in place to make sure that the company doesn't retaliate against a representative for representing the employee's interests, kind of thing.
Yes.
Yeah. So, not that we would ever impugn an employer for doing that, right? So, so I guess we're sort of moving along, and we only have a few minutes left. What I want to do is switch gears just a little bit and talk about immigration issues. And actually, this is quite timely because, as we well know, the construction sites around Bangkok were all shut down on just the day before yesterday, and now all those migrant workers and immigrant workers are now not able to work. So what sort of happens if somebody's an immigrant and all of a sudden they can't work anymore?
So I think in dealing with the foreign employees who hold work permits, employer should bear in mind always that the law would, once the employer inform relevant authority about the departure or end of the employment, then foreigners will have only 7 days to leave the country or apply for a new work permit. So the best way to help transition the employees as part of the mutual separation agreement that will be benefit to the employers. We've seen that the employer will facilitate this by setting the last day of employment to have sufficient time for the employees to really facilitate this transition, either go relocate back to home jurisdiction or move to work with a new.
So that, I think part of that is sort of standard practice, but I think right now the issue that you may have is obviously people can't leave the country or they can't go back to their home country. So how would an employer sort of accommodate if they have a big immigrant workforce that's not allowed to leave? I mean, is the government being relaxed about that, or?
We understand that there's certain relaxation right now in case that you are unable to leave the country because of the inability to find flight out, for example. And another way is to apply for conversion of visa type and use, for example, 30-day visa for tourists in that case.
So what I guess the other question I would have, the sort of last question on that point, what what sort of, maybe not legal obligation or formal obligation, but do companies feel some pressure to try to accommodate that process? Because again, migrant employees aren't going to necessarily know how the system all works. So are employers with big migrant worker bases sort of feeling as though they need to try to support those workers, or not financially, but I mean through the process, or help them with conversion, that kind of thing?
Yeah, I mean, especially because of the pressure of entering into mutual separation agreement. Mutual separation agreement can save a lot of costs on the employer's front, litigation fees, unfair compensation claims. So if the employer can get this mutual separation agreement, employees can waive a number of claims that the person may challenge the employees. So this is sort of a mutual incentive to ensure a smooth transition with respect to work permit and business visa. Maybe another thing that I want to update the audience here is because I mentioned earlier that there is a possibility of partial suspension of the business. We have seen court rulings that recognize that partial suspension of the business on the ground of force majeure, the employer has the right to impose that unilaterally on employees without having to pay any minimum salary. So Thai law requires 75% minimum of salary to be paid to the employees in case of partial suspension of the business on a business necessity basis. But in case of force majeure, for example, you are subject to direct government order to close down your business, then it has been seen and recognized by the labor court as a force majeure. So this, I think, an update that we received from our dealings in this front. I have not seen the Supreme Court ruling as yet, but we've seen the labor court issue this ruling recognizing this right.
Great. So I think that's all we have as far as the prepared remarks, etc. I'm wondering if anybody has any questions from the floor or anything like that that they want to ask. I'm not seeing anybody having published anything. But Tan, I'm just wondering if there's any additional information that we haven't sort of covered through this process that you think might be useful or helpful.
Yeah, so I think that the update around, or maybe another update would be, so for those business that are not subject to direct government order to close down, we have seen that either Department of Labor, Labor Welfare and Protection, or the Labor Court, they start to speak with us clearly that force majeure cannot be used.
Okay.
During the first wave of pandemic, we successfully used this and with the ruling to back it up. But after the situation passed for 6 months or 7 months, after the government stopped using the direct order to close down the business, then it will be more difficult at this stage. Recently, we had conversation with the DFDL officer and said that it appears that the business has the chance to adapt and adjust itself for around 1 year and a half already. So to really use force majeure where you not pay any amount of salary to the employees, that the idea will be deterred by.
So, I mean, we really want to thank Kraisorn for spending the time with us and answering or sort of presenting all this information. As you can see, labor force restructuring is incredibly involved and has a lot of different options and a lot of different opportunities for employers to try to accommodate the impact on their labor force due to COVID and due to the economic downturn that we've had and the uncertainty across all the economic spectrum. I want to thank everybody in the audience for joining us with the session today, and hopefully you will stay around for sessions 2 and sessions 3. If you could, before you leave, or at some point, if you could scan the QR code and provide us your feedback through a survey. It should be a very quick survey, so we much appreciate it, because obviously we want to improve our presentations and make them interesting and make everybody want to join as many of them as possible. And then also we have a publication that has been issued, and we update it fairly often, regarding government initiatives and support. So anytime the government issues some new support, etc., we try to update the COVID-19 government initiatives and support in Thailand publication for everybody to read, and you can download that from our website if you would like to do so. Okay. So again, I thank everybody for their participation today, and again, a special thank you to Kraisorn for taking his time to educate us on all of the alternatives and the issues and the pitfalls and the problems that may occur if you're thinking about workforce restructuring, etc. Okay. I think that's it.
Thank you very much.
Thank you very much, everybody. Really appreciate it.